pre-trial reviews in the matter of TCD 001-2023 and is being held by way of video conference before Justice Wayne Martin. Any orders or directions made during or after the conclusion of this hearing will be issued on the judge's instructions by the registry. Counsel for the claimant is Mr. Nathan Landis. Counsel for the defendant is Mr. Antonio Vervaro. Thank you.
Okay, thank you. All right, gentlemen. Well, I've read the pre-trial checklists, and I've just seen a trial timetable come through. Now, can you just remind me? I haven't really had a chance to look at it in great detail. Mr. Landis, did you provide that, or Mr. Varro, did your client provide that?
Your Honour, there should be some trial timetables on the case bundle online.
Okay.
Provided by.
All right, let me open that. Just bear with me for a minute. I haven't gone to that. Just hang on. All right. Case bundles. So I've got, and when I click on case bundles in the case management system, there's no records found.
Right. Perhaps I could email through to the registry.
Well, I've got one headed trial timetable commencing 12 February 2024. Is that?
No, that's the defendants, Your Honour.
That's the defendants. All right. Well, I haven't seen yours, Mr. Landis.
Let me address that right away, Your Honour.
Okay. Alan, perhaps when it comes through, you could immediately send it to me.
Absolutely.
Thank you.
It started this long journey, Your Honour.
Good. Mr. Landis, will you be trial counsel?
Yes, Your Honour.
Good. Mr. Varbro, will you be trial counsel?
Yes, I am.
Good. All right. Perhaps while we're waiting for that to come through, there's a couple of items that I'd like to discuss, and that is, in terms of the trial bundle, I say each of you have proposed that will be prepared by the 29th of January. Are there likely to be any issues in that regard? Does everybody understand what's going to go into the bundle and how it will be organised?
Well, I think that's the case, Your Honour. You might recall that at an earlier stage in the proceedings, both parties' pleadings had a number of documents exhibited to them. And I anticipate that will form the bulk of the contents of the trial bundle.
Okay, good. Okay. And Mr. Vivaro, is that your understanding as well?
Yes, it's very, very clear. And actually, I guess I guess the problem currently is not related to the bundle, but let me say to the agreement on the timetable, my lord.
Sorry, I didn't understand that last point, Mr. Vivaro.
I said that about the bundle, no issue at all.
Right, okay. But the timetable, there might be an issue.
The timetable has not been agreed, so that's the.
Yes, all right. Good. Well, when I get Mr. Landis's version, I've got yours printed off in front of me, Mr. Vivaro. When I get Mr. Landis's, we can discuss that. But
apologies, Your Honour.
Yeah.
I'm sorry to interrupt. I just wanted to confirm that it has been sent to you.
Oh, good. All right. Let me go to my inbox and see if I can find it. Just a minute.
Thank you.
Here it is. Good. Thank you. Just bear with me while I print that off as well, if you would, so I can compare and contrast. while that's happening, written opening submissions. Again, I think the rules provide a time for that, but has that been agreed, the date by which written opening submissions will be provided?
Yes, Your Honour, that was made by Her Excellency.
Right.
Okay. I'd like to say the 6th and the 7th of February are the two dates. Let me
right.
That.
Right. Okay. Good. Okay. And gentlemen, is it your expectation that those will be detailed opening submissions? Because that will be relevant to the amount of time that we should properly allow for oral openings. Mr. Landis?
Yes. Your Honour, you'll see in the trial plan that I've put forward that I do have quite a long opening submissions period, and that was on the basis that the skeletons that the courts recommend, which is based on English practice, are quite short documents. Although in saying that, I'm happy to adopt a longer form if that is a time saving.
I think in a case like this, I mean, it's a building and construction case, and the devil is in the detail in those cases. And I think the more detail I have in written form, the easier it's going to be. So I'd encourage you to err on the side of length rather than brevity. Mr. Vivaro, do you have any comment on that?
Yes, I believe that the opening submissions proposed by the claimant are quite long, and yes. I believe that maybe we can make it shorter. So actually, a slightly shorter time might be better. So that's why we propose it in our.
Well, that's fine, Mr. Vivaro, provided that I've got the materials that I need in the written openings. So in other words, if I don't have the material in either written form or oral form, then it makes it hard for me to write a sensible judgment. So
yes,
yes. All right. Well, that's going to happen on the 6th or the 7th of February. All right. Well, now I have both trial plans. Mr. Landis, would you like perhaps to start, given you're the claimant, and walk me through yours and why you're proposing different times to the defendant?
Of course, Your Honour. So Your Honour will see on the first day that has been devoted to opening submissions, and that was on the basis that the skeleton arguments are generally quite brief.
Yes.
But I'm grateful for Your Honour's indication that you'd entertain longer opening submissions, which would allow that time to be truncated.
Yes.
Going then, and that if that time is brought into a compressed form, then that will obviously impact the balance. Your Honour will see on Tuesday that we have the claimant's lay witnesses in the morning and the expert in the afternoon. Witness statements have been prepared, so that's really going to be time to cross-examine those witnesses by the defendant. So I'm in my learned friend's hands in terms of how long he'd like to spend with those witnesses. Similarly, on Wednesday, it's the same, except it's the defendant's lay witnesses in the morning and the defendant's expert in the afternoon. And then I'd propose taking the morning of the Thursday off to prepare written closings and deliver them orally in the afternoon with my learned friend on the Friday morning.
Yes. Yes, all right. Well, well, certainly I'll hear from you in a minute, Mr. Vivaro, but perhaps I'll just ask you, Mr. Landis. Contemporary practice in most courts and certainly all arbitral tribunals is to leave the expert evidence until all the factual evidence has been called. Whereas I see both of you have proposed that the claimant's expert would give evidence before the defendant's lay witnesses. Now, the disadvantage of that, of course, is that matters might emerge during the factual evidence of the defendant's lay witnesses, which should be put to the claimant's expert for his opinion. And that's why the practice has evolved of having all the factual evidence on before expert evidence is given. Is there any reason why we couldn't follow that practice in this case?
Not at all, Your Honour.
Now, Mr. Varvaro, what do you
No.
say about that?
No problem about that, about this
Okay.
practice. So we can postpone the witness, the
Right.
witness, the expert witness to after the witness.
So
of
after all the
Yeah.
after all the factual evidence is on.
Yeah,
Now,
yeah.
let me push you one step further, and that's the question of the expert witnesses giving their evidence concurrently, which again is common practice in many courts and is now, I think, become the default position in most arbitral tribunals. Now, there's a range of there's a spectrum, if you like, of types of concurrent evidence, sometimes called hot tubbing for those in Australia or America, whereby the witnesses give their evidence concurrently. In other words, the experts are sworn both at the same time. There are, as I say, a range of processes that you can employ. One is, if I might call it, the full-blown concurrent evidence / hot tub, whereby you have an agenda of topics, and then you follow the agenda with each party asking questions and then the experts questioning each other and so on. I wasn't going to suggest that in this case. I've come more recently to use a modified form of concurrent evidence, whereby the experts are sworn to give evidence together, but in a sense, they kind of give their evidence sequentially, but with some important overlaps. So in other words, what would happen under what I'm proposing is that the evidence would be sworn together. It's usual, again, in modern practice, to give each expert the opportunity to make an opening statement, sometimes accompanied by a demonstrative exhibit. So then each expert, if you like, gives the court and the parties an overview of their opinion and why they formed that opinion. And then so each does that. Then the claimant's expert witness would be cross-examined by counsel for the defendant, during which time I could ask questions following up from those asked by counsel for the defendant. And I could also invite the defendant's expert witness to comment on the answer given. And then that would be followed by the same process with the defendant's expert. So the defendant's expert would then be cross-examined by claimant's counsel, and I could intervene and ask questions for the claimant's expert to comment on the answers given. And then there would be an opportunity for the experts to ask questions of each other. And there would be another opportunity for me to ask questions of each expert. And then there would be re-examination, so that then the claimant would re-examine the claimant's expert, the defendant would re-examine the defendant's expert. The beauty of that is that it avoids the real problem of the expert evidence being like ships passing in the night, whereby the experts don't engage with each other, they proceed on different assumptions, and it makes it much harder for the court to work out what the real differences are. Whereas the kind of process I've just described makes it much easier for the judge, i.e. me, to know what the real differences between the experts are. Now, that process is very much enhanced if the experts have conferred and produced a joint report. Is that, I haven't gone back to the pretrial directions. Is that to occur?
No, it isn't, Your Honour.
Should that occur?
Well,
I know the experts are not identical in the sense that they're dealing with different subject matter. So I think you've got one expert deals with delay and quantum and the other deals with delay only. Is that right?
Yes. Well, it's also the type of delay, Your Honour. So the claimant's expert deals only with delay from the claimant's perspective, and the defendant's only deals with delay from the defendant's perspective. So the defendant's expert doesn't actually comment on the claimant's expert report.
Oh, really? Okay.
Yeah. So it seems it was prepared in June rather than October.
Yes. Well, should that be remedied? Is it planned to remedy that between now and the trial?
Well, that was one of the things I was going to raise with you today, Your Honour, that it seems that this truly is a case where the experts have passed in the night, and it is something that perhaps needs to be addressed by directions today.
Yes. Well, Mr. Vivaro, what do you say to that?
I believe that in this until now there has been a lack of cooperation, even in these preliminary matters, just to try to find a common point and dispute the points. As my esteemed colleague said, the two expert reports are related to a different perspective. So of course
Right.
we will be very glad to find a common points if there are common points which we can on which we can agree related
Well,
to the expert
well,
expert reports.
it sounds to me, gentlemen, as if the experts should be commissioned. And of course, we're only talking about delay because one of the experts doesn't deal with quantum at all. But on the subject of delay, I think I would have thought that this process ought to be that each expert ought to produce a report in reply to the report of the other expert, and then they should confer and produce a joint report setting out the matters upon which they agree and the matters upon which they disagree, with short reasons for their disagreements. Mr. Landis, what do you say to that?
Your Honour, that would be an excellent suggestion.
Mr. Vivaro?
I agree with your suggestion, my lord.
All right. All right. Well, then, how long would the experts need to produce reports in reply to each other?
Actually, I don't have any idea. I don't have any idea because this is a technical matter, so I can't interfere.
Well, and I agree with that, Mr. Vivaro. Rather than pluck times out of the air, the only problem is that we've got a trial starting on the 12th of February. So, and if there's going to be meaningful conferral and a joint report produced, that really should happen in the week. That should happen in the week before. That should happen in the second week before the trial. So the joint report is produced at least a week before the trial. So in other words, I would have in mind that the joint report should be produced no later than Monday, the 5th of February, which would suggest that
5th of February. Okay.
5th of February. So in other words, the experts would confer. Let me just pull up my diary. I think we're just, because of the exigencies of time, I think we're going to have to put in some dates, and if there are problems, I'll give you liberty to apply. But I think, working backwards, the joint report really needs to be available by Monday, the 5th of February, which means that the separate reports in reply really need to be available by what would it be?
26th.
Friday the 26th of January, wouldn't it?
Yes, I think that's right.
20.
That allows it in the
in
following
other words,
week.
which is
Sorry.
which is
Sorry, can you repeat, please? 26th of January.
So 26th of January. So the reports in reply should be provided by the 26th of January.
Okay.
Then the experts should confer in the following week, which is the week commencing the 29th of January, and then produce their joint report no later than Monday, the 5th of February.
Yes.
So obviously, gentlemen, I've caught you on the hop. You won't have instructions from your experts. You won't know if they're available. But if it's going to work, it really needs to be along those lines. But I'll give each of you liberty to apply to vary that timetable after you've had an opportunity to confer with your experts. But otherwise, there'll be a direction that, subject to that liberty, there'll be a direction that the experts are to confer. The experts are to produce reports in reply to the expert report of the other party no later than 26 January. The experts are to confer during the week commencing 29 January, and will produce to the court no later than Monday, the 5th of February, a joint report signed by each expert identifying the matters upon which they agree and the matters upon which they disagree, and in respect of the matters on which they disagree, short reasons for their disagreement.
Yeah.
All right. Now, I think what we should do, gentlemen, in terms of the concurrent evidence issue that I raised with you, I think we should simply stand that over at the moment until we've seen how that process unfolds. So in other words, when we see the reports in reply, when we see the joint report from the experts, and when I've had the opportunity to hear each of you in opening, I think we can then form a sensible view about whether the experts should give their evidence sequentially or concurrently. But provided they're both available at the same time, either sequentially or concurrently, then I think that works. Are the experts both based in Dubai?
The claimants is, Your Honour.
Yes. And Mr. Vivara, you're expert in Dubai?
Yes, he is.
Yes. All right. Well, I think we should try and identify a time by which those experts would be a day, ideally, when those experts would be required. So that takes us back to the timetable. Mr. Landis, if you got, assuming you file lengthier rather than briefer, shortening out submissions, how long do you think you need for opening?
No more than an hour, Your Honour.
All right. Right, so let's just using yours as the template. If we went there from 10:30, so that would go from 10:30 to 11:30 a.m. on your table. 11 p.m. sounds a bit later. 1 p.m. Oh yes, 1 p.m. So it'd be 11:30 a.m.
Yes.
And then Mr. Vivara, we could take a short break then, say 10 minutes, and then would an hour be sufficient for you?
How long?
An hour?
No, I didn't get for opening submission. For me, it's an half an hour.
Half an hour. All right. That's all you think you need. All right. Okay. Yeah. Well, then, so then we could break until 11:45, and then you'd finish your Mr. Vivara. You'd finish by 12:15. Then we could start. We could either start the claimant's lay witnesses then, or take the lunch break early. Then, any preference, gentlemen?
Probably makes sense to take the lunch break early, Your Honour.
Yes, why don't you take the lunch break early? All right. So then lunch from 12:15. How long do you want for lunch, gentlemen? 12:15, 1:30 or 1:15?
1:15 is fine for me.
Mr. Vivara, an hour for lunch or an hour and a quarter?
Half an hour. Half an hour is okay. It's fine.
An hour? Okay. So lunch will be 12:15 to 1:15. And then we would then commence the claimant's lay witnesses from 1:15. Mr. Vivara, how long do you think you would want to cross-examine the lay witnesses?
Maximum 1 hour, but maybe 45 minutes, more or less.
For each or for both witnesses?
So for each. So, let me say from 45 minutes to maximum 60 minutes for each.
For each. All right. Well, then why don't we go? So we're just, the rest of the afternoon will be claimant's lay witnesses. So 1:15 till whenever. Let's say 1:15 to 4:15 if needed. Okay. And then on Tuesday, we would then have the defendant's lay witnesses. Mr. Landis, how long do you think you'd need with them?
I think an hour and a half each.
An hour and a half each. All right. So then that would take us then. Yes. All right. So that would then take us, we do one witness from 10 till 11:30. Then we'd need a 10-minute break, I think. And then we could start the other at 11:40 and go through till 1:10.
Yes.
That would work. So we go from 10 a.m. to 1:10 p.m. That would be the defendant's lay witnesses. And that would mean we could then either, I'm in your hands, gentlemen, we could then either press on to the experts, or on that timetable, we could leave the experts until Wednesday and set aside Wednesday for the experts. And that would give the opportunity to take into account what the factual witnesses had said in case that needed to be put to the experts.
I'd be grateful if we put the experts across to Wednesday, Your Honour.
Mr. Vivara, are you happy with that?
Yes, I am, my
Yes,
lord.
all right. Okay, well then we'll set aside Wednesday for the expert witnesses, and they will either give their evidence concurrently or sequentially, and we'll decide that at lunchtime on Monday, after I've heard the openings from each of you. And then the proposal is that we have Thursday morning to prepare closing submissions. Mr. Vivaro, are you happy with that?
Yes, I am. It's fine.
Okay. So then we'd start, Mr. Landis, you'd go first, Thursday
Yes.
afternoon, and
Yes.
Mr. Vivaro, you'd have Friday morning, and then any reply submissions. And in terms of that, I mean, I've got until Friday. You can take as long as you like with closing submissions, gentlemen. So there's no, I mean, we're not going to be short of time in this case.
No,
So-
the estimate was deliberately a bit longer than
Yes.
perhaps was necessary.
Yes. All right. Well, that's okay because I've got to stay around for a trial the following week anyway. So and I can start writing the judgment. So well, rather than cast these things in stone, we'll just start on the basis we'll have openings for as long as they take. We'll start the claimants' lay witnesses on Monday afternoon. We'll have the defendants' lay witnesses on Tuesday morning for as long as they take. We'll have the expert witnesses on Wednesday, and we'll start closing submissions after lunch on Thursday. And
Okay.
I don't think we need any greater prescription than that, do we?
No, it's
Yeah. All right. Well, I think
Okay.
that's
Good.
that's clear enough then. And if we get a bit of time up our sleeve, then so much the better. Now, what else is there, gentlemen? Is there anything else?
No, from my side, no.
All right.
not from the
Mr.
claimants.
No.
No, you're right.
All right. Well, that's good. If there's any glitches, you know where to find me. So if you need, there'll be general liberty to apply, particularly in relation to that timetable for the expert evidence. If that's going to be a problem, perhaps get back to me. We probably won't need a hearing for that. I should be able to deal with any issues relating to that on the papers.
Thank you, Adam.
Okay.
All right. Is there anything else?
No, you're right.
No?
It's okay. Fine.
All right. Well, I look forward to seeing you both again in Dubai on the 12th of February.
Okay.
Okay.
Thank you.
Thanks, everybody.
Thank you.
Thanks for your
Bye,
time.
bye, bye.
Goodbye.